I will call case number 68197 in the matter of Jessica Lynn Siegel. I'll remind the parties that this is a compulsory discipline matter, which is an evidentiary hearing. So any exhibits need to be offered into evidence and any witnesses need to be sworn in. Would parties and counsel please state your appearances for the record?
Good morning, and may it please the board. My name is Amanda Cates, and I'm here on behalf of the Commission for Local Discipline.
Okay, thank you.
Good morning, may it please the court. My name is Grant Scheiner, S-C-H-E-I-N-E-R. I'm here for the respondent, Jessica Siegel.
Thank you. And I believe you said you were not going to put on any witnesses, is that correct?
We will not put on any witnesses.
Okay. You may be seated. Ms. Cates, would you like to give an opening statement or would you like to just proceed right into your presentation?
I was going to say, in the effort for brevity, I can waive an opening statement. I think Mr. Scheiner, there's a good chance he might want to give one, so if he wants to give one, I'm not opposed to that before I start my case.
Okay. Mr. Scheiner, would you like to give your opening statement now or wait until after Ms. Cates has put on her case?
I'd like to wait, Your Honor, and put it all in one.
Okay. Perfect. Makes sense. Ms. Cates, you may proceed.
Thank you, and may it please the board. This is a compulsory discipline case based on respondent's conviction of misapplication of fiduciary finance in the amount of $1,500 to $20,000, a state jail felony that was presented in the 178th District Court of Harris County, Texas. The commission filed its petition on August 22nd, 2023. Respondent was personally served with that petition and notice of hearing on September 18th, 2023 by Mark Whitmore, a private process server. Proof of service has been on file since October 2nd, 2023. On November 18th, 2015, respondent was charged by indictment with misapplication fiduciary finance $1,500 to $20,000, a state jail felony in cause number 1488846, styled the State of Texas versus Jessica Siegel, 3131 Yaupon Square, Houston, Texas, 77027. On December 7th, 2016, a judgment of conviction by court, waiver of jury trial was entered in the same case number. Respondent pled guilty to misapplication of fiduciary finance, $1,500 to $20,000, a state jail felony. Respondent was sentenced to 322 days in county jail and given 161 days credit towards incarceration, fine, and costs. At this time, I'd like to offer the following exhibits. Exhibit 1, a certified copy of the indictment in the stated cause number. Exhibit 2, a certified copy of the judgment of conviction by court, waiver of jury trial in the same cause number. Exhibit 3, original affidavit of Judith Gress DeBerry, attesting to the fact that respondent Jessica Lynn Siegel is the same person as the person identified as Jessica Siegel in the underlying criminal case. And Exhibit 4, an original certificate from Blake A. Hawthorne, Clerk of the Supreme Court, dated March 8th, 2024, indicating that respondent is licensed and authorized to practice law in the state of Texas. I would offer those at this time.
Thank you. Mr. Schneider, do you have any objections to exhibits?
No objection, Madam Chair.
Thank you. Exhibits 1 through 4 will be admitted.
May I approach?
Yes.
At this time, by entering a certified copy of the judgment in the underlying criminal matter, the petitioner has met their burden and therefore ask that we seek entry of a judgment of disbarment against Ms. Siegel.
Thank you. Thank you, Ms. Cates. Mr. Schneider, you may proceed.
Good morning, Madam Chair, Mr.
Morning.
Vice Chair, members of the board. The homeowners in Channelview, Texas don't know what to make of the banging sound that they hear from the inside of their storage shed. It's August 2016, it's a hot summer day, and the homeowners walk across their backyard and they hear the thumping coming from the tool shed. They open the door and inside they find Jessica Siegel. She's drenched, she's caked in mud. Her hair is frazzled and she's gaunt. It's obvious she hasn't been eating well. It turns out that she had fallen into a roadside ditch on her way over to the tool shed. The reason she was in the tool shed is because she heard voices, and the voices told her she needed to find her friend Jason. Her friend Jason had died some time before, but it was compelling to her, so she ran around that neighborhood in Channelview until she found the tool shed. Well, the homeowners called the police, and Ms. Siegel was arrested. She was arrested for criminal trespass. What she didn't know, what she couldn't know, was that things were going to get even worse. It wasn't always this way for Ms. Siegel. She was once a promising associate at Baker Botts. She was born on the north side of Houston. Her father was an engineer, although a brilliant man, an alcoholic. Her mother was a nurse, and she was a chain smoker, probably suffered from mental illness looking back at it. Ms. Siegel was a good kid. She always did what she was told. She was a good student in school. She was shy. She kept mostly for herself. When she got to high school, she tried to change some of that. She joined the drill team. She was in the National Honor Society. She was on the student council. And all the time, what was odd was that she felt as though this dark cloud was hanging over her. She would get sad, really depressed for days at a time, and she would be anxious. When it came time for college, well, she could have gone just about anywhere. She finished 11th out of 450 students in her high school class, and her dad said there's only one place for a future engineer to go, and that would be Texas A&M. So she went to Texas A&M. She did well there, but again, the cloud followed her. She was anxious, depressed, and one day she heard voices. She thought she was possessed by the devil. Now, being raised Catholic, she went and she sought the advice of a priest, a very nice man who was sympathetic but didn't really give her any answers. She went and saw a psychiatrist. The psychiatrist said, "Sounds like anxiety to me," and prescribed her Xanax. Well, the Xanax didn't do much to help her, but she was able to get through Texas A&M. And then when she got out, she graduated and got a good job in Houston working for General Electric. They made her a sales engineer. And she worked there, worked her way up the ranks for a couple of years, and then eventually they said, "We've got a great assignment for you." They transferred her to Charlotte, North Carolina, where there was practically an all-male staff there. She knew she didn't fit in well with the culture, but she didn't complain. However, when she got an opportunity to make a lateral move, she took it. She worked doing basically the same kind of work at a manufacturing plant in Blacksburg, Virginia. Blacksburg, Virginia is a rural area in southwest Virginia. She was alone. She sometimes drank, took alcohol. She didn't have really proper medication. But one really good thing happened to her. She met a man named Greg Siegel, and instantly they hit it off. Greg was a brilliant man. He worked as a software engineer for Virginia Tech University. So she and Greg get together. I should also mention that Greg was musically talented. He played the piano, he played the bass guitar, his favorite instrument was a guitar, he played in a band. Why is that important? Because like many band people back in that time era, probably still today, he used drugs. Cocaine was his drug of choice. He actually had Jessica try it for the first time. Well, while they were dating, Ms. Siegel became pregnant. And the two of them said, "You know what? We are meant to be together. Why don't we just be together?" So they became married, and they moved back to Jessica's hometown of Houston, which she liked. She got a job at NASA. He got a job for a NASA contractor. She did really well at NASA. She had a job in life sciences, doing projects and even training astronauts. She worked there for 6 years. They had a daughter, and then 2 more daughters from 1990 all the way on up to 96. And then she made a decision. She decided that she was going to follow her dream. She had always followed her father's dream of being an engineer, but she wanted to go to law school. That's what she really wanted to do. So she left her job and full-time enrolled in the University of Houston. And when she got there, the mental illness that had been largely kept at bay, interestingly, she found out that during pregnancy, she would have no issues at all. But once she got to law school, well, the stress was there. And she sought the advice of a psychiatrist. She said, this can't be normal. And the psychiatrist says, well, you know, you've been diagnosed as having anxiety in the past. There's an SSRI, one of those selective serotonin reuptake inhibitors. They were fairly new back then. They were, starting to use them off-label. In this case, they said, let's try it for anxiety. And although they didn't have the right diagnosis, they kind of had the right kind of medication, and it worked. At the University of Houston, she flourished. She did well. She was on law review. And then pretty soon, job offers came tumbling in. Baker Botts, Jenkins and Gilchrist. Gosh, if I could remember them all. Brown McCarroll Oaks Heartline. When she graduated, she chose Baker Botts. And she joined Baker Botts in their commercial litigation section and did quite well there. Had mentors who were very impressed with her work, future partners, current partners, thought that she was on a glide path, but she didn't have confidence in her own skills. And when Ogden Gibson made her a job offer, she made a lateral move. They tried to talk her out of it, but she went to Ogden Gibson, and she continued to do there pretty well. But at some point, things began to get difficult for the entire family. We remember Greg. Greg became ill.
Schneider, let me pause you for a second. The board is not unsympathetic to Ms. Siegel's story.
Yes.
But your presentation is not evidence. And
Certainly.
So I would encourage you to use your time to argue the legal issues in the case, or if you want to put on a witness to put on evidence, you can do that. But your presentation is not going to be evidence, and so it's limited. We have a limited ability to consider that.
I understand, Madam Chair, and I did account for that possibility. I do have exhibits to offer. May I offer those now?
Yes, please.
All right. We offer...
Have you provided those to the board? Thank you.
Indeed. And the board may have those as well. May I approach to offer the exhibits?
Well, can you identify the exhibits you wish to?
Certainly. Exhibits 1 through 13.
Could we just go through those one by one, and we'll give Ms. Cates an opportunity to object?
Absolutely. All right. So exhibit number 1 would be a shorter version of what I'm telling you now. So it's a letter from me to the board.
Ms. Cates, any objection?
I do object to this, as you just stated about the narrative that's being given on behalf of Ms. Siegel. And again, I am not unsympathetic, but the letter is not, it's not an affidavit, it's just a narrative letter from Mr. Shiner. And so not only is it not relevant to the issue at hand, it's improper because it has nothing to do with the burden of proof for a defense that Ms. Siegel is offering here today.
I'll sustain the objection to Exhibit 1 as evidence, but the board will consider it as additional briefing.
Thank you, Madam Chair. Exhibit number 2 is a letter from Jessica Siegel.
And I would make the same exact objection to this. And in regards to the letter being taken as briefing, Mr. Shiner and I actually had a conversation about these letters last week. He asked me to agree to these letters before he had sent them to me. I asked him to send them to me for review. He did not do so. Instead, he just filed them. And so I explained to him at that time that he had missed his briefing window. He's outside of time for briefing. So I have an objection to this being classified as briefing because he has not asked for leave to submit further briefing. And it seems a little disingenuous as we had a conversation about these and he usurped our conversation and filed them anyway.
Thank you. My ruling on Exhibit 1 will stand, I think. Exhibit 2 is admitted.
Exhibit number 3, Madam Chair, is a writ, a post-conviction Article 1107 writ that's been filed on behalf of the respondent. I believe we have a certified copy of that for exhibit number 3.
Any objection, Ms. Kate?
I don't have any objection.
Number 3 is admitted.
Madam Chair, exhibit number 4 is a letter from the Harris County District Clerk acknowledging the filing of the brief.
I don't have any objection to that.
Number 4 is admitted.
Exhibits 5 through 11, excuse me, are letters of support from various attorneys, beginning with Exhibit 5, which is from Honorable Jeffrey Brown.
Any objections, Ms. Kate?
The same objection as I made for the previous exhibits 1 and 2.
Exhibits 5 through 11 are admitted.
Exhibit number 12 is a picture of 6 sobriety coins showing 6 years of sobriety.
I'll reiterate my objection to the first 2 exhibits.
The objection to exhibit number 12 is sustained.
Exhibit number 13 is a letter from a psychiatric nurse practitioner, and that would be the last of our exhibits.
And what is the purpose that you're introducing that letter for?
To show that she's engaging in psychiatric counseling, she's undergoing a regimen of appropriate medication, therapy, and she's compliant.
Any objections, Ms. Kate?
I object this as expert testimony, and the individual has not been tendered or offered even as an expert witness, and so it is improper.
Objection to number 13 is sustained.
May I submit these just for record purposes so that you have the whole stack?
Of course.
Thank you. So I will summarize the remainder as to say that from that point on, the time of the tool shed, she was in and out of jail, homeless. For the panel's edification, I wondered how a person can be homeless. Apparently, what Ms. Siegel did was she lived in an abandoned building with other vagrants and drug users, and she had become one of them. When she needed to shower, she showered at truck stops. Most of the time she was homeless. She, of course, had no insurance. Her mental health issues went completely untreated, unmedicated. The date of the misapplication case, which is August the 4th of 2014, falls right in a terrible time period, unfortunately, for Ms. Siegel. She had been a victim of terrible physical abuse, a live-in boyfriend, because she had no place to go, beat her so badly that she had bruises all over her torso, and her eyes took several months to heal. They were swollen shut. And that's when the misapplication happened. She saw an opportunity to have $9,400. In her delusional thinking, she thought she could take the money and pay it back. And of course, that was wrong to do and completely wrong in her thinking. And that's what she did. She wanted to move out on her own. She had burned through her life savings. 3 of her older children had moved out. She lost the 4th, her son, to Child Protective Services, which frankly at the time was probably the right thing to do. And as a result of all of these arrests, which include criminal trespass, possession of a controlled substance, state jail felony, less than a gram of methamphetamine, and this misapplication case, she had spent a total of 161 days in jail. As far as I could tell, there was no effort to reduce her bond. She was given a court-appointed lawyer, and then, unfortunately, Ms. Siegel pled to something called a 1244A. 1244 is the section of the Texas Penal Code that allows for felonies to be handled with county jail time. 1244A results in a felony conviction. 1244B results in a misdemeanor conviction. We'll put a pin in that because I know that as an intentional crime, that probably doesn't make much of a difference. But no one made any effort, apparently, to do anything, as far as I can tell, to lower her bond or to charge bargain. She was charged with possession of a controlled substance, state jail felony. Same level as the misapplication case. And the misapplication case, look at Petitioner's Exhibit Number 1. It's the indictment. And I'm sure Mr. Vice Chair has seen many, many indictments, as have some of you. You will notice a glaring thing that pops out at you looking at the indictment. The indictment doesn't even name a complainant. It would be like having a murder case with no murder victim, or an assault case, even a shoplifting case lists
Excuse me, I
somebody.
think Ms. Cates wants to make an objection.
I'm trying really hard because I do think that it's important to hear everything that Mr. Schneider wants to talk about. But relitigating or pointing out any defects in the underlying criminal matter do not change the fact that a plea was entered by Ms. Siegel for the crime. The crime that he's readily admitting to that. So if there were underlying issues with the criminal, that's for the application for the writ that he's filed, that's for some kind of appellate matter, but it's really not relevant to what we're here to talk about today.
The objection is sustained. We can't relitigate the underlying case, so we need to focus on what effect that has on the petition
Absolutely.
for compulsory discipline.
Thank you, Madam Chair. Exhibit number 3 is the writ. And so all of this is in the record. And I'm trying to frame what is going on here, which is that it's almost unfathomable that I'm standing on this square of carpet and we're arguing about this case because it never should have happened. With a defective charging instrument and a person with a lot of credit for time served, if you've got another case, you go on the other case. And if she had pled to the drug case, the possession of a controlled substance, I'm certain that that's not an intentional crime requiring compulsory discipline. I'm not even sure it's a serious crime which would require suspension. So that's the way in 999 out of 1,000 instances this would have been handled. I don't understand how the indictment got past not only the Harris County District Attorney's intake and the prosecutors, but the defense attorney and even the judge. So we have filed a writ. And here is what I'm asking for, given these extraordinary circumstances. There are 3 things. First, the moonshot that I know is not realistic, which is don't do anything to suspend or disbar. But I'm very aware of what is statutorily required. Another way to do it would be to not disbar and merely suspend. Now, to do that, the intentional crime would have had to be fully probated. I think In re Caballero from the Texas Supreme Court in 2008 talks about BODA's discretion in an intentional crime scenario where it's fully probated. This is not fully probated. It's not even partially probated yet. I am hopeful that in the interest of justice and the fact that we've got cognizable claims in the writ, that the district attorney's office will join us in this. It's important to note here that Ms. Siegel is a good candidate for that because after the plea, she decided she just wasn't going to go out that way. So with no support and no help from anyone, she went and found a psychiatrist who gave her the proper diagnosis. And then she got on an appropriate regimen of counseling, therapy, and the right kind of medication. She voluntarily enrolled in a 12-step program. She's repaired broken relationships. Her son, whom she had lost to CPS years ago, is in the courtroom today. She's come a long way, and she is practicing law again. I am here to ask that she be given the opportunity to continue to do that, to make something of herself, and more than anything else, and I know my time is probably winding down, but she should be a model for all of us. This is a person who went and, after hitting rock bottom, had pulled herself up and become a functioning human being and the good lawyer again. She's back to being the good lawyer. She can be the example that we can all follow. I know we want to help lawyers who are in trouble. But the best way to help lawyers who are in trouble, who have hit rock bottom, is to give them examples of other lawyers who made it back. She's made it back. And what I'm asking us to do here today is to keep her back. So, here is one thing I propose that this board can do, which is nothing. Let us litigate this writ. Give me a time to do that. Check back with me periodically to see what progress is being made. If I can get this conviction set aside, then the whole reason for us being here is gone. I really think that everything that she's been through and everything she's had to do to get back here, she's earned that opportunity. And I'm hoping we'll give her a chance.
Thank you, Mr. Shiner. Ms. Cates, would you like to provide a brief rebuttal?
I can do it as a closing argument if you don't mind.
Okay,
I don't have any other evidence to put on.
all right, you may proceed.
Do you want to do it from here, or what can I approach?
Wherever you're more comfortable. Oh,
I'm usually very loud. It's here that all of a sudden I'm not, which tells you many things. I appreciate all of the information that Mr. Shiner has given on behalf of Ms. Siegel, and I want to make it abundantly clear that the commission is not without sympathy for people in similar situations as Ms. Siegel. But the commission has two jobs. One is to protect the profession, and one is to protect the public. And the fact of the matter is, to protect the public, we have to impose discipline, and strong discipline, on attorneys who violate the rules, and then the statutes tell us what we have to do in this particular case. There's really no discretion on my part. There's no discretion on the board's part. It says that upon a finding and an entering of a conviction of an intentional crime, and it then specifically states as an intentional crime that theft or the misappropriation of, a fiduciary duty, that's exactly what happens here. And the statute says shall be disbarred. There's literally no discretion, and a lot of times I wish there was, and I do understand and feel deeply for Ms. Siegel. But there are no defenses to be had, nor
I think his suggestion isn't that we ignore the statute. I think his suggestion was that we wait and see if the statute applies after his efforts bear fruit or not. Could you address that?
Absolutely. The problem is there's no discretion for that. It says upon a finding of a final judgment of a conviction, and the conviction is final. There weren't any appeals because she pled.
That doesn't sound like it's rushing us to enter anything. That sounds like we have to do it, but I don't hear a time frame there. I mean, I see time frames all over the statutory codes. Must act by 30 days, or it happens by operation of law. I'm not hearing any of that. I'm just hearing it says we have to do this eventually. And I'm not saying you're wrong. I want you to address exactly what he's asking for, not the easy part.
I think that his argument, the problem is he's not making an argument that you have the ability to do that. And I'm telling you the way I interpret the statute and the commission interprets the statute is not only is that not required, but that's not a discretion that is present, because the statutory language and burden of the commission has been met in full. And so it should be followed out as quickly as possible in the sake of protecting the public. This case, the arrest was in 2015. In 2016 is when Ms. Siegel entered her plea. And Ms. Siegel did not let anyone, there was not a requirement, a mandatory requirement at that time to report such a crime to our office, which I believe is largely why there's not a statute of limitations on a compulsory discipline as pursuant to Rule 17.06 of the disciplinary rules. So, and I think it used to be to account for, and this is rampant speculation on my part, but I
Can you
think,
slow down a little bit, Ms. Cates, to make sure our court reporter can get down what you're saying?
I apologize. I got very excited about his very good question. And so, had Ms. Siegel told us about the conviction back then, we could have given her the 5 years disbarment. I mean, it would have been a disbarment, but she would have already been eligible to reapply. And it sounds like that's the time in which she most needed to have the downtime. And so now, unfortunately, because she didn't tell anybody, even though she was at the time of her conviction was eligible for disbarment and likely should have been disbarred significantly back then. I mean, significant amount of time back then, not significant disbarment. However, I think that's why it's so important for you to act now. We have already gone so long without allowing the protection for the public for Ms. Siegel to really take a look at how she practices law, why she wants to practice law. It's imperative that we don't wait another undetermined amount of time to rectify the situation and the wrongs that happened.
And I definitely agree with you that the application of the power of the state in these criminal and even civil punishment matters, time matters. If you wait, it loses a lot of its effect, and I think there's been a lot of evidence of that. But we've waited now. That ship has sailed, sunk, and been sold for salvage, and now we have what I think is one of the most difficult problems that ever comes before us, and that is, we look for redemption stories all the time. Mercy is a huge part of our job. But often the cases that come before us, as hard as we try, they feel irredeemable sometimes. And those are just heartbreaking. And what's even harder is to find someone who has actually found some measure of redemption, which is what we're trying to accomplish here, and then come to us and ask us to unwind that is difficult.
I do not disagree, and I do not envy the task that you are set. However, to give you sort of an analogous situation, in the event Ms. Siegel had appealed her criminal conviction, and asked for a trial, been through a trial, been convicted, and appealed her conviction, we would have come to this board and we would have asked for an interlocutory order of suspension, because that's what the rules say we have to do. I have no discretion in bringing that case statutorily as the commission. And she would have been put on downtime. That wasn't even allowed to happen because she pled. And so there's been no recompense for the wrongs that happened and the people that were affected previous to now. So I think it's a disservice to the profession to not hold someone accountable when the statutes tell you exactly what to do without any further discretion.
Thank you.
Any other questions for Ms. Cates?
I have a question for Mr. Shiner.
May I?
Yes.
Yes, Your
You
Honor.
filed your writ. Do you have a setting?
Do we have a setting?
Do you have a setting on the writ?
No, we don't have a setting on the writ. We're waiting for the state's response, and I hope to meet with someone high up in the chain at the district attorney's office.
How long do you expect the writ to take? You've asked us to reset this for an indefinite period and check with you periodically. That is not going to happen, I can assure you. How long is the writ process going to take?
I should say, I should have known better than to say something like that in front of a judge. Mr. Gross can probably speak to this. It would take a period of months, but we're hoping to truncate it and make it shorter than that, because we hope that the district attorney's office will join us in the writ. We hope they won't fight us in the writ. And if all else fails, we would explore something. I suppose we could always do a nunc-pro-tunc, try to probate the judgment and do other things. But we're hoping it's going to be a relatively short, maybe a 90-day window. This is speculation on my part, Your Honor. But I would be willing, eager to check in with this board every 30 days to give you a progress report.
Not going to happen.
Well, whatever the board requires me to do, I will do. All I'm asking for is a chance to do it.
Let me ask you, Mr. Shiner, so in Harris County, some counties, the district clerk's office will send it right up to the Court of Criminal Appeals right away to see if it's a proper writ or not, needs a hearing or not. Does Harris County do that?
What Harris County does, Mr. Vice Chair, is first, after they file it and they docket it, they send it over to an associate judge, and then they give the state a chance to reply to it. And if it seems like there's something that needs to have the record developed, then they'll call the parties in and develop it. but eventually will go to the Court of Criminal Appeals, the Court of Criminal Appeals to do its gatekeeping function. But right now, the next step is we're going before an associate judge. I have a pretty good idea which one or two we're going to land before, and we're waiting for the state to respond.
And what part of the record would need to be developed? The voluntariness of the plea or your, I heard you kind of hint that you thought that there was like a fundamentally defective indictment.
Yes, Your Honor.
There's not a record that would need to be developed in that, is that correct?
That's correct. That wouldn't require it, but I think the involuntariness of the plea, because
How does this fall outside of the traditional voluntariness of a plea analysis when you're looking at a collateral consequence? I mean, this is in effect a collateral consequence, correct?
yes, it is. And I'm glad you brought that up, because by analogy, you look at Padilla issues, where somebody's immigration collateral consequence, a lot of judgments were set aside because the pleas were involuntary. The defendants were not adequately informed of the collateral consequence.
Those are
of
IAC
immigration.
claims, not involuntary plea.
That's
Sixth
correct.
Amendment.
And I don't see an ineffective assistance of counsel claim in your writ. Is that correct?
That's correct. We can amend that. I don't want to couch it as an ineffective assistance of counsel claim. I could, and I will if I need to, but right now it's a question of straight voluntariness, which if the state joins us, that's a cognizable claim. We don't need to do that. I would prefer not. I will do what I need to do for Ms. Siegel, but that is where we are right now.
Thank you.
Mr. Shiner, Ms. Cates has argued that we are essentially statutorily bound to rule, that we have no discretion here under a particular time frame. Can you please address her argument? I haven't heard you address that specifically.
Very well, and thank you for the question. There is nothing in the statute, we've looked this over and discussed this issue, that says there's a time deadline that BOTA must, rule on by thus and such a date. You could, if you wanted to, as a board, you could adjourn the hearing and then pick up the hearing at some point in the future.
Do you have any authority that we have the discretion to delay our ruling?
No. All I have is, I don't find any authority, I've looked for it, that says that you have to rule within a certain number of days of a hearing. You could adjourn the hearing, you could ask the parties to brief the issue, you could do whatever you need to do, and I'm hoping you'll give us at least some breathing space.
So what does 808 have to do with it? The no supersedious? I feel like we're just doing an end around of Rule 808. Could you talk about that, please?
All right, so I'm not...
If we do what you ask, and I'm not suggesting that we are, but if we do what you ask.
All right, I don't see that as an end around. I just see that as the board exercising its discretion. I mean, you can rule in any time frame you wish. And it seems that this is one of these rare, compelling cases where you might want to wait to find out a little bit more. Because if the writ is successful, then all of this goes away. But if she is disbarred in the meantime, it will do immeasurable damage to her livelihood and to her career. Probably irreversible damage. So under these rare circumstances, I'm asking for the board to exercise its discretion. Let me say this, and I'll answer whatever questions are posed, but perhaps this is the last thought. Every lawyer who has come in contact with this case has failed in some way. Every prosecutor, every defense lawyer, even every judge. Errors were committed. People didn't do things they were supposed to do. None of us was ever caught. There is a suggestion here that maybe Ms. Siegel, who at the time was homeless and mentally ill, should have discovered the error and appealed it within the 30-day window that she has for that. Which she had, I think, if this were called to the attention of the judge, who was the judge at the time, and the chief prosecutor, whom I know, and who was the chief prosecutor at the time, I think they would have clearly set this thing aside. But that's not what happened. And that's not Ms. Siegel's fault.
Thank you. Any further questions from the board?
Ms. Cates, what happens if the board doesn't set this off, goes by your interpretation of the rules that we have to rule timely now? What happens if she's disbarred and then is successful on the habeas?
Then we'll need to go through.
I'm sorry?
We'll need to go through proceedings to vacate the disbarment,
Okay.
which do exist. I mean, we can, in fact, Ms. Siegel had other charges that she was convicted of in Montgomery County back in 2014, I believe, which is in the documentation that Mr. Shiner has provided. And she was put on an interlocutory suspension pending the appeal of that, which is why it makes it difficult for the commission to say that she didn't know about the consequences, because she actually went through this back in 2014 when she was put on the interlocutory suspension for the other charges, which were then set aside and vacated on appeal. And so the interlock was dismissed because there was no longer a charge. So it's possible, what I'm telling you is it's absolutely possible for the disbarment to be vacated through some other procedural mechanism.
And how long does that take?
I do not know the answer to that question because I was not here when that happened, and I am not entirely sure. I think a large part of it would depend on what procedural mechanism would need to be taken and who initiated it. We would also have to know that it was vacated, so I don't have a specific answer for you, but timely, as quickly as we could accomplish it, we would want to do it in the efforts of, protecting the profession and the public.
Board Member Stone, may I add something to that to amplify that?
Please.
Last time, it took 3 years to set aside an illegal judgment. She was acquitted. I mean, the only reason we brought that up, because acquitted behavior generally isn't even relevant. It just happens to show up on a public background check, another one of the many collateral consequences that goes along with things like this. And it took her 3 years, and the damage was immeasurable. And it is actually a terrific example of why we shouldn't take action if there is a reasonable possibility that that action will be set aside.
Any further questions? All right, thank you both for your presentations and arguments. The board will take this under advisement. And you're excused?
I was going to ask that question,
Yes.
Madam Chair. May we be excused?
Yes.
Thank you.
All right, the board will call case number 68536 in the matter of Landon Stephen Keating.
Madam Chair, as Mr. Westcott set up, can I get a little bit of clarification on the board's ruling on the plea of jurisdiction? I'm asking so I know what to argue going forward. Does that mean the board has determined that Mr. Keating's offense is a crime of moral turpitude, or would you still like me to argue that?
We have not made that decision. We've just decided that it's not a jurisdictional matter, it's a matter of the merits.
Thank you very much.
Madam Chair, take me just a minute to get set up.
You bet. Does the board need a break?